In this video, you are going to learn the three biggest secrets that you must know to win your domestic violence restraining order hearing. My name is Veronica, and I am a domestic violence restraining order defense attorney here in California. I help people put their cases behind them so that they can enjoy their lives and their freedom. Now, I actually created a course called Defeat the DVRO, in which I teach you from A to Z everything that you need to know to win your domestic violence restraining order hearing. And as part of that, I created this free master class, a boot camp, if you will, with the three biggest secrets that you need to know to win your hearing. And I posted it on my website. So you put your email address in, you register, and you get the free class. But I am super excited about this master class. And so I decided that I wanted to show it to as many people as possible by putting it here on YouTube. And for people who take the free masterclass from the website, I also give them an exclusive discount on the entire course. Against probably any business advice that I have ever received, I'm also posting the link to the discounted version here too, so you can find it down below in the description. Now, I'm not crazy, and I know that I can't just put the discounted version out there for everybody forever, so I'll probably take it down eventually. But for now, take advantage of it. So without further ado, here is the masterclass. Did you know that you can successfully defend yourself in a restraining order hearing and win? I know it sounds crazy because we are so used to hearing about hiring attorneys to represent us in court. And while that's important in some cases, I'm going to share with you three secrets today that are going to revolutionize the way that you approach that restraining order that you were served with. So, what's the secret to winning your restraining order hearing? It's preparing in advance. It's knowing what to expect and how exactly to prepare. So, I'm going to share with you three secrets about restraining order hearings and how you can win yours and take back your life. I know you're probably thinking, how am I going to represent myself? I see what those lawyers do on TV, and I don't know if I can do that. But again, I'm going to show you a great way that you can prepare for your domestic violence restraining order hearing and get amazing results. Secret number one is learn what the judge is looking for. Now, the big idea here is that the judge must follow the law, and the law tells the judge to look for specific things. This is important because if you know what the judge is going to be looking for, then you can hand it to the judge on a silver platter. So first, let's talk about what needs to be proven and who needs to prove it at a domestic violence restraining order hearing. The petitioner is the person who filed for the restraining order, the person who's claiming that they were abused. They're the petitioner, and you, the person who's responding to this thing, defending against it, you are the respondent. The burden of proof is on the petitioner. If the petitioner does not present sufficient evidence, then no domestic violence restraining order will be granted. You, the respondent, you don't have to prove anything. Now, how certain does the judge have to be? The petitioner is presenting proof, right? But how much do they need to convince the judge? The standard for domestic violence restraining orders is more likely than not, aka 51%. Now, you may have heard about beyond a reasonable doubt before. That's for criminal cases. It's not the same here. More likely than not, 51%. And what exactly does the petitioner have to prove? The petitioner needs to prove that a restraining order is needed to prevent future domestic violence. So it's not just about whether abuse occurred in the past. It's whether a domestic violence restraining order needs to be issued to prevent domestic violence from occurring in the future. Now, what counts as domestic violence? This is something that a lot of people don't know because a lot of words in court are not used in the same way that we use them in everyday speech. So most people, when they think of domestic violence, they think about hitting, physical injuries. And that is a form of domestic violence, physically hurting or trying to hurt someone intentionally or recklessly. Sure, yes. Sexual assault, yes. But it's also making someone reasonably afraid that he or she or someone else is about to be seriously hurt. So this includes threats or promises to harm someone. Now, this is especially important to know because if there are threats in text messages, for example, maybe something that you didn't really mean that you sent in a moment of anger. I don't want you to underestimate your opponent. You don't want to think, hey, you know what? She's got nothing. She just has some text messages. She's not even saying that I hit her. I've got this in the bag. No, that is a form of domestic violence, and you need to be prepared for it. There's also behavior like harassing, stalking, disturbing someone's peace, or destroying someone's personal property. Those can all be considered domestic violence. Now, what is relevance and why is it important? Okay, so only evidence that's considered relevant is allowed in court. So any testimony or other evidence has to be relevant. Stick with me, I'm going to explain what that means. So relevance means, and the test for relevance is, does a piece of evidence or a fact relating to one of the things that needs to be proven, does it make that more likely to be true? So I'll give examples of some irrelevant information. Actually, I just got a YouTube comment that had something that the person writing it thought was really important, but I think is most likely not relevant. They said that the petitioner gave me a disease and I have proof. I have a voicemail of that. Well, you have to ask yourself, does that make it more or less likely that domestic violence occurred such that a domestic violence restraining order is needed to prevent it from happening in the future? If I were the petitioner, maybe I would want to bring that up because I would want to perhaps show, okay, I gave him this disease, I cheated, my bad, but then he got really angry with me and he committed an act of domestic violence and I'm scared and I need this domestic violence restraining order to help me and prevent that from reoccurring. You see how that works there? But if he tries to bring that up, she gave me a disease, that's not going to be compelling to the judge. So who pays rent? Who broke up with who? If you are the respondent only, like you didn't file a restraining order against her too, which in general I don't necessarily recommend, the other party's abuse of you is not going to necessarily be relevant. Now you may want to try to slip at least some of it in to give the judge some context here, but don't try to take that too far. You may be thinking, hey, look, the petitioner is representing herself. She's not going to know any of this. The judge knows this. And when you start trying to bring up other things, and when the judge has 30 cases that he or she is trying to hear, he or she's going to cut you off probably pretty quickly. You're going to get frustrated and you may even give up if you're like, what can I even say? And I've seen it happen. So you don't want that to be you. Secret number 2, understand how to present your evidence. Now, the main idea here is that if you have evidence on your side, it doesn't do you any good unless you can actually show it to the judge. So you need to know how to show the judge your evidence. Evidence is called when you present an actual document in court. Exhibits. When you are preparing your exhibits, first you're going to want to prepare any text messages. Text messages are present in almost every domestic violence restraining order hearing. Now, make sure they're relevant before you think about presenting them. But what you're going to want to do is be sure to capture the time and date as much as possible. This can be tricky. If you have an iPhone and you have access to a Mac, you can sign into iMessage, and if all of the messages were iMessage, you can save as a PDF. There are some apps that do this. If you're not able to do that, or if you don't have a whole lot of time before the hearing, of course you can take screenshots, but make sure that they have the time and date. Number of copies. You should bring 3 copies to be safe. Don't only bring 1 copy. You're going to need a copy for the judge. You're going to probably need a copy for the other party. Many times courts will force you to give a copy to the other party, and if you fail to do so, you won't be able to use it. And then you want a copy for yourself so you can show the judge and be able to explain the exhibit without trying to blindly describe a document. If you have audio or video, first of all, to be very safe, I would have a transcript of it. There's actually a rule of court in California that says that you need to have a transcript of any audio that you're going to be playing unless you have good cause not to do so. Now, maybe you have a video recording that does have audio, but you don't need the audio, it's not necessary, or there's no dialogue or something, of course, that's fine. If you do have a lot of audio that you're trying to use, then I would recommend using a service like rev.com. It's pretty fast and they'll create a transcript for you. So if it's, something that's like a half hour long, that's going to take you a really long time to transcribe. So I recommend using them. They have a version that just has like AI do it. That's pretty quick and cheap. And they actually have, I think, a free trial, maybe up to 10 minutes. But I recommend doing the version that starts with the AI and then actually has a human going through it. They're really good. And then be sure that you are not recording illegally. So if you're in California, it's a two-party consent state. There is an exception for if, for example, you are recording evidence of a crime, or if the recording took place in an area where the other person would not have an expectation of privacy. So Ring video cameras, for example, that are outside of a house, commonly that will come in. But if you had, a camera in your living room that the other party didn't know about, then you're probably not going to be able to use that. But if they knew about it, they installed it, or it was obvious that it was there, then you have a decent chance of being able to use it. If you do have a lot of exhibits, a lot of text messages, then binders might be helpful. As an attorney, I prepare binders. If you prepare binders and you bring in 3 binders, the judge will be impressed with you. The judge is impressed with attorneys who do this. So for sure, the judge will be impressed. That can be really, really helpful in making sure that the judge has all of your exhibits, that everything is really well organized, and that you think through also, hey, in what order am I going to present these exhibits? I recommend chronological order. If you have audio or video, especially video, my recommendation is to call the courtroom in advance and ask them about how to present video. Here in California, even just within the county of Los Angeles, some courtrooms have great AV systems, audiovisual systems. Some of them don't have any at all. I usually will call in advance, but I'm also bringing 2 laptops. I'm bringing an HDMI cord. I've had to buy and bring in a speaker once, actually for a murder trial, because that court's particular AV system was horrible and I had really important audio to play in defense. So yeah, you do want to figure that out before. Don't come just with a bunch of exhibits on your phone. That's probably the worst thing you can do. There's a decent chance that you won't be able to use them at all. When to present exhibits. Okay, so there are 2 times when you can present your exhibits. The first time, and the order of this restraining order is going to be that the petitioner goes first and then the respondent goes. So the petitioner gives her statement, then you get to ask the petitioner questions. So you can present your exhibits when asking the other party questions. So if you're using it to discredit the other party, there is actually a way where you can bring it up and kind of pull it like a rabbit out of a hat during your questioning of her. Now, if you don't know how to do this, and I explain this in the full-length course, but it is pretty long, so I'm not able to do it in this one. If you don't know how to do it, then I recommend not doing it. Just skip that part. Don't try to do it clumsily, especially because, tensions, emotions are high during these restraining order hearings. But you can use it when you give your statement, and I will move myself out of the way here. I recommend that you do present your evidence during your statement, even if you already used it when you were asking the other side questions. And you want to make sure that when you're using it, you explain to the judge what the exhibit is. For example, these are text messages exchanged between the petitioner and me on whatever date. And I took screenshots of these text messages from my phone, and then you end with, and this is a true and accurate copy of the text messages. And that's really important, and that is one thing that I do teach you in the course. I give you exact scripts because there are lots of these weird, who would know just without learning anything about this, you're supposed to say true and accurate copy. There's all this lingo and legalese that sometimes you can get away with not knowing in court because the judges are a bit more lax for these restraining order hearings when people represent themselves. But if you can use it, you pretty much guarantee that it's going to go smoothly and you impress the judge. And as the respondent, that is what you want to do the entire time. Secret number 3, learn how to discredit the other party. Now, the key point here is that you can't approach a restraining order hearing the same way that you would approach other arguments with your ex. You need to know how to ask her questions in court and how to poke holes in her story. Now, let's go through a key example of how to discredit the other party. This is one of the cross-examination styles that I teach. This maybe is the simplest one to get across quickly, so that's why I chose it here today. This is cross-examination style number 2, which I like to call, and I've nicknamed, were you lying then or are you lying now? If you've watched a lot of court TV or you have any legal training, you may know this as prior inconsistent statement. So, if the petitioner changes her story from what she wrote down when she was trying to get the restraining order and what she says in court, you want to bring that up. But how do you do it? After she makes her statement, as I mentioned, you get to ask her questions. Now, I highly recommend typing out the petitioner's statement and bringing a laptop so that you can easily locate her prior statements during the hearing when she's testifying. I like to use the search tool, the find tool on my computer, especially if it's a really long statement that she hand wrote. How are you going to be searching through that during the hearing and also listening? It's too difficult. You want to be fast. That's one of my key ways that I win trials, that I win restraining order hearings, is being fast, being able to locate that. I think that that's a killer secret. I don't know a lot of lawyers who do that, but it works so perfectly. Now, be careful. Use this only for important facts that would not be easily forgotten. Don't use this for every small detail. Dates, exact times, those kinds of things are not necessarily going to be all that important. I would say you probably only want to use this between 1 and 3 times during the restraining order hearing. And I mean, that's a general rule. Some of these hearings go on for a really long time, but you don't want to go crazy with this. And I'm emphasizing this because I've had clients both in criminal and in domestic violence restraining order cases that really want every single one of these details to come out. And if I do it as a lawyer, the judge will probably get annoyed with me. But if you do it as the respondent, you're going to look bad. You're going to look nitpicky. You're going to look the opposite of how you want to look, and you're going to make it that much easier for her to get the 51%. So don't do that. And then make sure to, and I'll move myself out of here as well, make sure to commit by getting her to agree that she's absolutely sure. And we'll go through that right now so you can see exactly what I mean. Okay, so here's a scenario. The petitioner wrote on her request for a domestic violence restraining order that during an incident that she claims happened on Thanksgiving Day, you struck her in the back of the head. So that is what she wrote down. She never mentioned anything at all about being hit in the face, but she has now testified. Now, today in court, she's testified that during that same incident on Thanksgiving Day, you repeatedly struck her in the face, not in the back of the head. Pretty big difference, right? So how do you point that out? This is how you do it. Your first question will be, you testified a few minutes ago that on Thanksgiving Day, I struck you repeatedly in the face. She's going to say, yes, that was my testimony. Second question, you're absolutely sure that I struck you in the face. Now, this is what I'm talking about when I say make sure to commit her to it. You want her to say she's absolutely sure, because then when you pull out the statement that she made before that is completely different, it doesn't give her wiggle room to say, well, maybe I forgot, or I wasn't really sure today, or I haven't had my coffee this morning. It takes away those excuses. That is key, because those excuses will come, and you want them to fall flat. You want her to lose credibility, and you want it to be impossible for her to get 51%. You wrote a statement as part of your request for a DVRO describing me hitting you on Thanksgiving Day, correct? She's going to say yes. And you signed that statement under penalty of perjury. Well, yes. You promised to tell the truth the same as you promised today, correct? She's going to say, well, yeah. And then this is the part, this is the zinger, right? Isn't it true that on your DVRO, you wrote, he struck me in the back of the head? And she might say, yeah, but the judge won't like that. The judge is going to want her to just answer the question. And really, what can she say, right? She's already changed her testimony and she's already committed. She said she was absolutely sure. Isn't it true that on your DVRO, and this is the super zinger, you never mentioned anything about me hitting you in the face? You got her. How is the judge, if you use this question format, if you bring this up, how can the judge believe her? Now, I know what you're thinking. I don't know if I have enough time before my hearing to learn all of this. Well, the tricky thing is that you really only need to learn a few key lessons to implement during your hearing. And so I've created this course called Defeat the DVRO that will help you learn everything that you need to know to win your hearing. You'll be able to go into court completely organized and ready. Your ex will not even see it coming. You'll have objections to keep her evidence out. You'll be able to present your case perfectly. You'll be able to discredit her, and you'll impress the heck out of the judge, way more than if an attorney was representing you. And so what this is going to do is it's going to give you the best chance at winning your restraining order hearing. And I, as a domestic violence defense attorney who has over 10 years experience winning these hearings, what I do is I give you all of my best tips, all of my best tricks and hacks, the exact easy things that I do to beat any petitioner, any attorney every time. So what I've done is I've summed up everything into an easy to follow course. I've created an outline for you to fill out and follow. It's all fill in the blank. Now, I've given you 3 key secrets, but the truth is that defending a DVRO, it does go further than this, and that is why I created the course. There are resources in this course that you will not find in any other place, website, or video on YouTube. And I mean, you can go there and try to find the resources. You can even go to the court website, and you'll find very little for respondents. That's what my course is here for, to tell you everything and to give you the keys to success so that you can win representing yourself. Now, if you click the link below, you can get the full course for a discounted price that's only available to you and only available today. I honestly don't know how much longer we'll keep this course available, and prices will probably go up because, frankly, people are learning that they can take this course instead of hiring me. So click the link, get it today while it's still available for a discount. I'm always here to help. And I can't tell you all the amazing results that we've gotten for respondents who are struggling with defending themselves against these restraining order hearings. I can't wait to see you on the inside. Have a great day.